Thank you very much. Can I remind members to observe the social distancing measures which are in place in the chamber and across the campus, including when entering and exiting the chamber and when accessing and leaving your seat. The next item of business is a Conservative Party debate on motion 24205 in the name of Liam Kerr on prisoner voting. And can I invite members who wish to speak in this debate to press the request to speak buttons now, and I call on Liam Kerr to speak to and move the motion.
Thank you, Presiding Officer, and up front I will move the motion in my name. During the Shetland by-election in September 2019, the SNP used ministerial diktat to sneak through a change to the franchise and bypass parliamentary scrutiny, allowing prisoners to vote in that election. Then last year, they pushed through a bill which allows prisoners serving sentences of 12 months or less to vote in Scottish elections. As a result, this May, the Scottish Parliament elections will be decided with the votes of convicted prisoners who are serving their sentence in Scotland's prisons. But what does that mean for people watching today, Presiding Officer? Well, according to the Scottish Prison Service, 540 criminals who right now are in prison will be eligible to vote. The SPS notes that this figure could increase by polling day. Now, I know the Minister is fond of a quote, and here's a good one. In my opinion, those who have been convicted of more serious crimes, particularly those of a sexual nature, violent crimes, and crimes that harm people, have forfeited their right to vote. The First Minister was perfectly correct when she said that in November 2019. Now, the latest statistics show that in 2018-19, nearly 10,000 criminals received a custodial sentence of 12 months or less. Let's interrogate those figures, Presiding Officer. 100, I won't. Let me make the point, Mr. Arthur. Let's interrogate those figures, Presiding Officer. 119 criminals are currently in prison on a 12-month or less sentence for attempted murder and serious assault. 37 are inside for 12 months or less for sexual assault. And there was even someone convicted of homicide, sentenced to 12 months or less in prison. All eligible to vote. And let's look more closely at some of those the SNP will enfranchise in May. A serial criminal, previously convicted for attacking police and robbing a bookies, currently in prison for 12 months for assaulting a prison warder. A convicted rapist who breached a sexual offender prevention order, currently serving 12 months in prison for that breach. A criminal who, using racist language, threatened to kill lawyers and judges, obstructed police officers and spat in a police vehicle, currently imprisoned for 12 months. A criminal currently in prison for 6 months after first threatening to kill a hotel porter, doing his job, and then assaulting a nurse. Presiding Officer, it is morally repugnant that those who commit crimes such as these should be granted the vote. It is not right, it is not fair, it is not just. I'll take an intervention.
Tom Arthur.
I'm very grateful to the member for giving an intervention, and he's perfectly entitled to view. The issue I take with what he has stated is a suggestion that the SNP pushed this change through. As the member knows fine well, changes to the franchise are protected under the Scotland Act and require a supermajority. So how can he describe a vote of this Parliament by supermajority as the SNP pushing it through? Will he withdraw that statement because it is patently inaccurate?
Liam Kerr.
Mr. Arthur's summary is indeed a fact, as is the fact that the Minister and his colleagues founded upon a misunderstanding of the Hurst judgment in order to push that debate through. And I'll come to the Hurst judgment right now, because I think, Presiding Officer, there are actually a lot of MSPs in here who agree with me. But like the Minister's amendment, will seek the comfort of their misunderstanding of the European Convention on Human Rights. They think, look, I don't like it, but we must do this to be compliant with the ECHR. Well, Presiding Officer, that argument is fundamentally flawed, because nowhere does the Convention accord an individual right for prisoners to vote. Indeed, for 23 years, until the European Court of Human Rights sought to discover it in the Hurst case in 2005, there was no such right. However, even if we accept that judgment as sound, and by the way, I remind members that Professor Tompkins described the Hurst judgment as, quote, one of the worst judgments that the European Court of Human Rights has ever handed down, predicated as it is on a false premise that there is a blanket ban on prisoners voting in the UK, the Minister himself reminded the Chamber in November 2019 that members who are familiar with the Hurst ruling know that the Court allows Member States a wide margin of appreciation, and that There is no one-size-fits-all approach to ensuring compliance. Now, that margin is part of our law, and the Law Society of Scotland made clear during the debate into the franchise that the franchise of prisoners may be restricted, provided that the restriction is proportionate to achieving a legitimate aim, such as enhancing civic responsibility, respect for the rule of law, and avoiding sanctioning law-breaking conduct. And that, presiding officer, is why the United Kingdom's solution to the Hurst case, to give the right to vote to prisoners who are released on temporary licence, has been accepted as a solution by the Committee of Ministers, which is the enforcement agency of the Council of Europe. That is why the European Court has never found that the United Kingdom's refusal to comply with that ill-considered judgment should result in any kind of damages for disenfranchised prisoners from the United Kingdom or any government within it. And that is why this Parliament is not and was never required to enfranchise prisoners by Hurst. So let there be no doubt, presiding officer, that any member who votes to enfranchise prisoners at decision time tonight will not be required by law or legal principle to do so, because compliance with Hurst can be achieved by going no further than what the rest of the UK does. Now, I appreciate that there are members who understand that, but believe that rehabilitation prospects are increased by giving prisoners the right to vote. They suggest this on the supposition that participating in elections is likely to encourage them to become responsible, law-abiding citizens through what the Minister called active citizenship. And in a debate last year, Alex Rowley said, policy should be driven by evidence. I couldn't agree more, Mr Rowley, because when the bill referenced in the Minister's amendment was debated and passed, neither he nor any member of this chamber adduced a single shred of evidence to suggest that giving prisoners the vote increases rehabilitation. There is nothing to that effect in the Audit Scotland report reducing reoffending in Scotland, nor was it evidence in the Equality and Human Rights Committee report, which included the following quote from a criminologist who has studied the issue. I have not found evidence to say that the introduction of prisoner voting will lead to a lower rate of recidivism. Presiding officer, I predict the final refuge of those who seek to justify giving prisoners the vote will be a plea to some form of right to vote. But I ask them to reflect on this. Victims, such as those who have suffered serious assault, attempted murder, sexual assault, which are crimes that in the past few years have attracted sentences of 12 months or less, will be watching this debate, and they will be asking, where were my human rights? What happened to my right to freedom from discrimination, my right to security, my right not to suffer inhuman or degrading treatment? Presiding officer, when I walk out of the chamber after decision time tonight, I will look victims and relatives in the eye and say that my Conservative colleagues and I voted to ensure no individual serving a prison sentence should be allowed to vote in the 2021 Scottish Parliament election. My conscience will be clear. Will the other parties be able to say the same? Thank you.
Thank you very much. And I call on Michael Russell to speak to and move Amendment 24205.1.
Thank you, Presiding Officer. Presiding Officer, again and again the Conservatives come to this chamber and denounce the choice of a topic for statement or debate. It's ironic, therefore, that they've chosen to give up an hour of their debating time, virtually their last hour of debating time in this Parliament, for what is a naked political gesture that is as cynical as it is hollow. This debate, as we have just heard, has nothing to do with justice or democracy or even fairness. It has to do with trying to shore up the core hard right vote in Scotland. It is a sign of Conservative desperation. The Tories know full well you cannot overturn legislation of any sort, let alone legislation passed by a supermajority, with a single sentence motion debated for an hour on a Wednesday, 4 weeks before dissolution. So no matter what happens today, I'm sorry, I just want to make this point because I think it is essential that we say what the situation is. So no matter what happens today, even if this motion is passed, it would be a meaningless, empty gesture. And the Tories know that. That is an abuse of this Parliament. If the Tories were in any way serious about this issue, as opposed to just exploiting prejudice, then they would have come here with a new bill to reverse the change. That's what it would take. They know that. That's not what they've brought. And they know that too. I give way to Liz Smith.
Liz Smith.
I have to say, Cabinet Secretary, to talk about abuse of the Parliament, I think in this week is a bit rich. But can I just ask the Cabinet Secretary, is he aware of the most recent YouGov polling, which is showing that 2/3 of the public want our point of view.
Michael Russell.
What I'm aware of is two things. One is the cynical exploitation of a range of issues this week by the Conservatives. I'm familiar with that. I think it is a disgrace, and I think they will pay the price for it. The second point is I am fully aware that when the issue is explored and talked about properly, people tend to be on the side of fairness. They don't tend to be on the side of prejudice. Let me now carry on with this, because what the Tories would have had to bring to this chamber is an emergency bill, because they've known what the situation is for a year, but they've come this week. And that would require the process to be implemented. It would require us to be the second ever bill and the only ever emergency bill that would need a supermajority. But what message would that bill actually send out to the people of Scotland? First, that the priority of the Tories was not COVID or education or health, but themselves and their hard-right views. Secondly, it would send a signal about our willingness to welcome short-term prisoners back into society and about this Parliament's concern for human rights and the rule of law, which some things the Tories pretend to support when it suits them. It would trample all over the Gould principle that argues that changes to electoral law should not be made less than 6 months ahead of an election, something the Tories regard as sacrosanct in other circumstances. It would send a very odd message that this Parliament might be willing to radically change its mind on an issue it endorsed by an emphatic margin just a year and 4 days ago. In fact, it wasn't pushed through. It was 92 votes to 27, with all the parties voting for it except the Conservatives. It would be about a tiny number of people. There were 643 prisoners in custody serving a sentence of 12 months or less 2 days ago. Many of these people will not register to vote due to the length of their sentence and unwillingness to do so. It would negatively impact on electoral registration officers who are currently busy processing large numbers of new postal vote applications as a result of a pandemic. Thus, no, I won't. Thus, it would make the operation of our democracy harder. And finally, and most dauntingly of all, it resurrects the incompatibility with the European Convention on Human Rights that inspired the Franchise Act in the first place, and in so doing would put Scotland back at severe risk of significant penalties. Presiding officer, this franchise was extended to prisoners serving sentences of 12 months or less by the will of this Parliament by 92 votes to 27 on the 2nd of April 2020. The bill that led to this change was passed under the supermajority procedure. It was the first and so far only bill of this Parliament to require that majority. It was not pushed through, it was democratically decided. The view of democracy that the Tories gave is a sham and should be shown as a sham. Before the change, the government conducted a consultation in which only a third of the respondents opposed permitting any prisoners to vote. The Standards Committee took evidence on it, and it unanimously concluded that the blanket ban on prisoner voting is unsustainable as it is at odds with the European Convention on Human Rights. I will lean on legal opinion, not on the opinion of Liam Kerr, who I have to say has set himself up against the entire body of jurisprudence on this matter and expects us to believe him. So, presiding officer, this Tory motion, I will give way, not because Jamie Harcrow-Johnston shouts from a sedentary position, because I'm interested to see how more arrogant he will become, Mr Kerr.
Liam Kerr.
Yet again, we find ourselves, presiding officer, in a situation where the Cabinet Secretary is conducting what I would consider disrespectful language towards a member of this Parliament who is entitled to make their points, and as is the Cabinet Secretary. But I would ask for your opinion, your suggestion, whether that was to describe a member as arrogant in that nature is acceptable language.
I would remind all members of the need for courtesy in language in referring to each other within this chamber.
I'm grateful to the Minister for taking the intervention. So why did the SNP government go further than it was required to do under Hurst when giving criminals the vote?
Michael.
Well, presiding officer, it did not go further than it was required to do so. What it did was it put in place a sensible solution, which was a solution that has been used elsewhere. I cannot account for the fact that Mr Kerr seems to regard himself to know more than the entire European Court. I can't account for that, but I can tell him he doesn't. And I hope that is not disrespectful, but it's actually a fact that he doesn't. Now, Presiding Officer, this Tory motion today is not about cons voting, as their weekend pre-publicity voted. It's actually a con on the people and voters of Scotland. It's a con on this Parliament, and it's a very cruel con on victims, because it is telling them that something can happen which cannot happen. Because there is no way, as I said at the start of this, that this motion this afternoon can bring about a change of the law. And if that is what the Tories are promising to victims, then they are guilty of a cruel hoax to those victims, and they should apologise for it. I can look them in the eye and say that. I hope the Tories can apologise for their prospectus, their false prospectus, this afternoon. My amendment, Presiding Officer, wipes out this offensive motion. It replaces it with the facts of the matter. I hope it will be supported across the chamber today, perhaps even by those Scottish Conservatives, and there will be some, who recognise the shameful nature of what their leader, one of their leaders anyway, has forced them to bring here today.
Thank you. I now call Rhoda Grant.
Thank you, Presiding Officer. It's very obvious that there is an election in the offing. This debate today is sadly a waste of all of our time. Prisoner voting has been debated and voted on only a year ago in this Parliament, and there's no evidence that it requires review. And even if there was a need for review, the Conservatives know that there is not enough time in this Parliament to do that. The Scottish Labour Party believes that we must abide by our obligations under international human rights conventions, regardless of whether they sit comfortably or not. As others have said, the history of this is that in 2005, a case was brought by John Hurst, a British prisoner who had been convicted of manslaughter. The European Court ruled that a blanket ban on prisoners voting violated the ECHR's provisions on the free expression of opinion on elections. Crucially, the court found that considerable lawful restrictions could be placed on enfranchisement, not of prisoners, but the same test relating to the duration of sentence or severity of the offence had to be applied. Restricting voting to those serving 1 year or less ensured that we were not open to legal challenge, but importantly recognised also that for the most severe crimes, civil freedoms must also be restricted. The primary purpose of imprisonment is to protect people and communities from offending behaviour. Prisons are also used as punishment for crimes by restricting freedoms. However, punishment is a secondary concern. The first must be the protection of victims and communities. Therefore, imprisonment for crime must also be used to stop offending behaviour, to ensure the convicted person addresses their behaviour, changes it and is fit to return to society without risk to the public. It also enables them to contribute positively to society. Voting can be seen as a right, but also as a privilege. But it is also a responsibility to society, a duty to elect a government that looks after our collective interests and runs the country. To be encouraged to vote, to take that responsibility, can be seen as a step towards rehabilitating offending behaviour. The Conservative Party have long attempted to brand themselves as the party of law and order. Yesterday, they voted against an instrument that reduced the hours required to fulfil community work orders. And I think this will portray them as being tough on crime. However, on the most basic analysis, their logic is flawed. The alternative they appear to want is that despite COVID-19 restrictions, these work orders should be completed, putting not only the lives of those serving the orders, but those that they work with and those who oversee their completion at risk. Perhaps they would prefer that these orders become unworkable and that more people end up in prison when it is patently not the right place for them to be.
Liam Kerr.
Yeah, I'm very grateful. I'm interested in the member's characterisation of this, because if the member truly believes in rehabilitation, how can she support the cutting of 300,000 unpaid work hours giving out to criminals, which are supposed to rehabilitate them?
Rhoda Grant.
Indeed, and you were at committee and heard the questions I asked of the Cabinet Secretary ensuring the work that went towards rehabilitation was carried out, that support was still in place, and that indeed alternatives to physical work be considered for them to do. So Scotland already has the largest prisoner population, rates per head higher, the highest in Western Europe, and overcrowding is already at dangerous levels and absolutely unsafe during COVID-19. In the middle of a pandemic, there are much more important things for the Conservatives to debate, and this is incredibly frustrating. We could be debating the help available to businesses to get them through the pandemic. People losing their livelihoods will wonder what on earth is going on and who could blame them. The truth is that the pandemic and its ensuing poverty will cause devastation in our communities. It is damaging mental health and it is deepening inequalities and deprivation, the very social drivers that we know can increase criminality. We should be using this time to debate how we stop that happening, how we deal with mental health issues that lead to offending, how to prevent desperate people from choosing between survival and legality, and how we create a society where we no longer need to have overcrowded prisons. Let's rebuild a fair and just society. That is what Scottish Labour are interested in, and I believe it's what the public are interested in too.
Thank you very much. I now call Liam MacArthur.
Thank you, Deputy Presiding Officer. The Conservatives' motion today rings a bell. That's because Liam Kerr and his colleagues have previous. In the run-up to the general election in 2019, the Tories chose to spend their debate time pitching proposals for whole-life prison sentences. That debate, like the one today, had nothing to do with improving community safety, the lives of victims, or even the small matter of operating within the realms of what is actually legal. Then, as now, it wasn't due to a lack of things to focus on, even in the justice arena alone, from overcrowded prisons rife with COVID to an under-resourced police force facing its own issues around mental health. The sole purpose of both debates, Deputy Presiding Officer, is to posture and grandstand ahead of an election with no hope, intention or expectation of delivering change. While this Parliament should be looking towards recovery and new ways of doing things better, in justice as in every other area of policy, this motion speaks to a tired old political logic that by blowing the dog whistle, making unsubstantiated claims based on fear not fact, votes will come running. Presiding Officer, Liam Kerr needs to ask himself if that has any credibility. The public understands that our communities are safer when we invest in smart justice. They understand that a vote is a voice and that having a voice matters to people. They understand that imprisonment should be a chance to give people who have done wrong the opportunity to do right in the future. That is why this Parliament was right in overwhelmingly supporting a change in prisoner voting rights, as the Cabinet Secretary rightly reminded us. The previous blanket ban was not fair, progressive or legal, nor did it help rehabilitation or make our communities safer. To reduce reoffending, we need to make people more aware of their responsibility as citizens, not deepen their sense of alienation. So the language used by Douglas Ross around this debate has been both illogical and irresponsible. Canada, Ireland, Denmark, the Netherlands, all offering voting rights to prisoners. Strangely, those democracies remain intact. For those who care about the rule of law, this motion is a wolf in sheep's clothing. A blanket ban on prisoner voting would break the law. As with the debate on whole life sentences, the Tories are asking Parliament to agree to something that breaches ECHR. Liam Kerr knows that. Douglas Ross knows that. As I say, though, Mr Ross and his colleagues have previous when it comes to wanting to sidestep judicial rulings. Moreover, in the midst of a pandemic, with businesses, schools and our health services crying out for help, there were perhaps more pressing issues for the Tories to choose for debate. Then again, some in the Conservative Party will always make time to bash out a tired old tune on the trusty old dog whistle. Deputy Presiding Officer, Scottish Liberal Democrats reject the regressive, evidence-free and counterproductive approach proposed by Liam Kerr and will be supporting the amendment in Michael Russell's name. Thank you.
Thank you very much. And I now call on John Finney.
Thank you, Presiding Officer. Presiding Officer, the election of a dishonest, racist and misogynist leader, the UK Prime Minister, might suggest that Tories believe in redemption and the power to change. We know that's not the case. Tories are about privilege. Tories are about building barriers, devising bogeymen. Tories are about contempt for human rights. Tories are about disregarding Scotland's Parliament, ignoring uncomfortable evidence and spouting continual negativity. Scotland's Tories are about undermining Scotland's institutions and the people who work for them. There's 3 facts in that motion. It's a fact that this was required to comply with a ruling from the European Court of Human Rights. It's a fact that that legislation enjoyed a super majority support. And that was the will of the Scottish Parliament that the Tories often purport to have regard. And it's a fact that similar actions have been taken elsewhere, as other speakers have said. And it's certainly the case from the motion that the Scottish Parliament will take the action that it considers necessary to comply with human rights legislation. Scottish Conservatives are the nasty party, the party of the rape clause, the party of austerity, the food bank party, and they are proud of it, Presiding Officer. The Tories belittle alternatives to custodial sentencing, and therefore those who work in our criminal justice social work departments and their third sector partners. Scottish Greens believe in a criminal justice system that seeks to prevent crime by addressing one of the principal causes of crime, poverty. Tories create poverty, blame and place no value on those in poverty. The so-called Law and Order Party, Tories south of the border hand out public contracts to their mates, to their donors, no procurement process, no need for ferries to have a ferry company, then smirk when they're found out by the courts for whom they have contempt anyway. Tories know nothing about compassion. Tories know nothing about rehabilitation. You only need to see their words on the issue of drugs. And Tories care nothing about the rights of children, the evidence of harm, their stance on equal protection of children, simply shameful. Now, I value Shrieval judgment in Scotland.
Point of order from Liam Kerr. Excuse me, Mr Finney, we have a point of order from Liam Kerr.
Welcome if the member, or I seek your guidance as to whether the member will actually bother to address the motion at any point this afternoon.
This is an opening speech in relation to the debate, and I expect Mr Finney to address the motion in front.
What I'm doing, thank you, Presiding Officer. I'll come on to the judgment. I value the Shrieval judgments in Scotland and rulings of the European Court, not the rantings of Mr Kerr and his understanding of them. We want to see robust and well-resourced alternatives to prosecution, robust and well-resourced alternatives to custody, and an end to ineffective short-term prison sentences with little chance of constructive work. We want participative and inclusive democracies, and we know that the Tories don't like Johnny Foreigner voting either and want to impact the franchise even further. We should be encouraging every jailed father to vote in a local authority election where the education of their child is an important issue. We should be encouraging every inmate with a history of addictions to vote when funding decisions about addiction services are a key issue. A casual observer might think the Tories have called this wrong in this debate, but they know exactly what they are doing. They're separating themselves out on the ground, away off to the right. So let this Parliament distance ourselves from that unpleasant group of hypocrites and reassert our view, expressed not that long ago, that we value human rights, that will value the work of our prison staff. We believe rehabilitation is a key element of that, and voting has a role to play in that. The Scottish Green Party were and remain fully behind the franchise legislation passed just a year ago, and we will be supporting the amendment in the name of the Cabinet Secretary Michael Russell at decision time tonight. Thank you, Mr. President.
Thank you very much. We now move to the open debate. I remind members we are tight for time, so a strict 4 minutes, please. I have, can I now call Liz Smith to be followed by Rona Mackay.
Thank you, Deputy Presiding Officer. And can I say at the outset that I am strongly opposed to prisoner voting and have been for a very long time. But I hope my decision is based on careful consideration of both sides of the argument, not on arrogance, not on a lack of compassion, not on nastiness, and not on knee-jerk reaction. And that careful consideration is, to my mind, very important. So too should be the scrutiny in this Parliament, which is why the Scottish Conservatives will make no apology for restating our case in this party business debate. I think there are two key aspects to the debate. What might be termed the more philosophical approach, and what might be seen as the more practical approach often identified by the public. Where both these approaches come together is the view that those who commit a crime have not only broken the social contract in philosophical terms, but they have put themselves outside the law voluntarily, having chosen not to value the privilege of citizenship and civic virtues. And as such, in my opinion, they should be denied the opportunity to decide who will make the laws for the time that they are in prison. Disenfranchisement also reinforces society's denunciation of criminal activity, something which leads many in society to believe that prisoners cannot be trusted to respect the will of the people and abide by the law. Incarceration is a period of removal from the normal freedoms and privileges of society, such as personal liberty, the right to privacy, and some freedoms of speech and expression. To weaken these privileges is the aspect which most fuels public anger. And as Liam Kerr so rightly said, there are serious criminals in prison just now serving 12 months or less who might well end up voting in this election. So it's not just their victims who are angry about prisoners having the vote, but it's the public at large who feel that there is an inherent unfairness and wrong that prisoners are permitted to vote. And I'm sure that's why in the last YouGov poll, 63% of people are against prisoners having the vote. And of course, that is roughly the same percentage who believe that the current justice system does not hand down sentences which fit the crime. Now, many people argue that prisoners deserve a second chance, that permitting them to vote provides them with the necessary respect and responsibility to prepare them for the outside world once they have served their time. But for me, that is a privilege that should only be accorded once they have demonstrated that they have become law-abiding and upstanding citizens once again. In any case, there is no evidence to tell us that the prisoner voting cuts reoffending rates, which, if there was convincing evidence, might have some greater influence on this debate. I do, however, accept that it's important to distinguish between those who have served their time and those who are still in prison. Once an individual has completed his or her sentence, he or she should be free to participate again in public life. This whole debate is a balance between citizenship and redemption, hence why former prisoners should be immediately handed back their citizenship and freedom once they have served their sentence. So in conclusion, voting in elections is a democratic right, but it is one that has to be earned. It is not a given right in every circumstance. Voting is about having a stake in society, and allowing prisoners to vote would mean politicians are arguing that criminals have the same right as others to elect those who make the law. That, in my book, cannot be right, and I don't think many of the members of the public, perhaps even some members in this chamber, actually think it's right. Indeed, I think there will be many members of the public who will seriously question in May why prisoners should be free to vote from their cells when many other people will be making huge efforts to attend a polling station. Deputy Presiding Officer, I am utterly convinced that prisoners should not be voting, and I wholeheartedly support the motion in the name of Liam Kerr.
Thank you very much. I call Rona Mackay to be followed by James Kelly.
Thank you, Presiding Officer. The Conservative motion we're debating this afternoon is both surprising and baffling in my opinion. Can I associate myself with the remarks of previous speakers, Rhoda Grant, Liam MacArthur and John Finney? The motion is surprising because, as we've heard, the issue of prisoner voting was decided by a supermajority in Parliament last year, and to revoke that would be incompatible with our human rights obligations, which the Conservatives undoubtedly know, despite Liam Kerr's spin on the Hearst case. And it's baffling because it throws into question the Conservatives' whole attitude and approach towards building an effective, rehabilitative justice system fit for the 21st century, one which most countries in the world are now striving for. Prisoner voting is focused on human rights and is an important part of the rehabilitation process. Similar actions on prisoner voting have been taken in other parts of the UK and widely across the world as a progressive step towards reshaping the justice system into a humane and civilised institution. The European Court of Human Rights has stated, "The right to vote is not a privilege. In the 21st century, the presumption in a democratic state must be in favour of inclusion." Do the Tories seriously want our government to endorse such a regressive step? For our country to be isolated in their short-sighted view of rehabilitation in our justice system? This is not soft justice, as they are fond of saying, it's rough justice. The Scottish Elections, Franchise and Representation Act sends an important message about our willingness to welcome short-term prisoners back into society. It was the first bill in the Scottish Parliament to require the support of a supermajority of 2/3 of MSPs. Parliament voted 92 to 27, with only the Tories voting against the bill. Making a change now to the law on prisoner voting would also disrupt preparations for the election by changing the franchise, and would mean committing to using the remaining short time left in this Parliament to rush through a new bill to reverse the change. Again, I imagine the Conservatives know this, but still submitted the motion. But of course, populism and sound bites are par for the course for this party. A sure sign of desperation, as the Minister said. Surely the aim of promoting responsible citizenship within the context of the wider objectives of reintegration in order to reduce reoffending is the goal if prison is to mean anything. Presiding Officer, we know much more now about the reasons why people take the wrong path into crime and end up incarcerated. It often starts with childhood trauma, a lack of early intervention, deprivation, abuse, neglect, and many other barriers that are not easily overcome. Exclusion from the electoral process could add to their sense of marginalisation in a way that would hamper efforts to encourage rehabilitation and reduce the risk of reoffending. Is that really what the Conservatives want? It's hard to understand just why Douglas Ross and the Scottish Tories find Scotland meeting our human rights obligations as appalling. In addition to the UK, the only Council of Europe countries which have a blanket ban on prisoner voting are Armenia, Bulgaria, Estonia, Georgia, Hungary and Russia. By contrast, the Council of Europe states that have no restrictions or virtually no restrictions on prisoner voting are Croatia, the Czech Republic, Denmark, Finland, Ireland, Latvia, Lithuania, Norway, Slovenia, Spain, Sweden and Switzerland. The Welsh Government has accepted that prisoners serving custodial sentences of less than 4 years should be granted the right to vote in devolved Welsh elections. The Conservatives might like to pretend they're the party of law and order, but the evidence shows it's the SNP's decisions in government which have had a positive impact. The government's firm focus on early intervention, crime prevention and the rehabilitation of offenders has meant less crime and fewer victims than a decade ago, key indicators of what works. Alongside reforms strengthening the rights of victims and vulnerable witnesses, the draft budget delivers increased resource funding of more than £18 million for services to support victims of crime and deliver measures to improve their experience of the justice system. So in conclusion, Presiding Officer, I think the Tories would do better to use their time working with the government to progress a rehabilitative prison system rather than submitting pointless motions like this. Thank you.
Thank you. James Kelly, to be followed by Fulton McGregor.
Thank you, Deputy Presiding Officer. Like many other MSPs across the chamber, I receive numerous emails every day with people's concerns, particularly in light of the pandemic. People are worried about their health and their family's health. They're worried about businesses, about jobs, about the impact on the education system of pupils not being able to attend schools in person. They're worried about the impact on the economy. So there's a lot of issues that people have got coming into their mailboxes. I have to say that I haven't had one email about prisoner voting, and therefore it's surprising that the Conservatives have chosen to use their time today, an hour of parliamentary time, which could have been much better used on issues that are much more important to the Parliament and to the people throughout Scotland's communities. I also think, as others have pointed out, this issue was well debated thoroughly through committee and through all the stages when the consideration was made to change the law in relation to prisoner voting. It was not, as Mr Kerr says, rushed through. It takes quite something for legislation in this Parliament, not only to be passed by a supermajority, but to be supported by 4 of the 5 parties in the Parliament. So it was very much a considered position that the Parliament had reached this time last year. I spoke in that debate, and the arguments I submitted for supporting the change in the law, I think, stand the test of time. First of all, in terms of compliance with the European ruling, we couldn't simply continue to ignore that. And we also couldn't toy with it around the edges. I think a responsible government and a responsible Parliament must ensure that we have an area of solid compliance. I think the arguments that many made, including the Third League for Penal Reform, for a change to the system were valid. And I think they were valid really because of the case that's been made for the importance of rehabilitation. And we, on the Justice Committee, when I sat on that, we heard about it a lot. And I heard Mr Kerr talk about the benefits of rehabilitation. And he seems to have turned his face against that today in support of the motion. So I think it's really regrettable when there are so many big issues, such an important time for the country and the Parliament, that the Tories thought to use an hour of their debating time on an issue that was resolved a year ago and in practical terms, couldn't be altered over the next month. The reality is Parliament reached a settled view on it, and it's not something that's going to be altered at this minute in time. I think what the Tories have done here is just naked electioneering. They're basically tub thumping to a small group of right wingers in the country. This is an election tactic that will fail. Ultimately, when it comes to the election, the issues that matter are the issues that will make a difference in people's lives. How do we ensure post-pandemic that people have proper jobs and have support in their jobs, have support in their businesses? How can we ensure that the health service fit to deal with the many people who have had delayed appointments? How can we support our pupils and students in education? These are the issues that the Parliament should be debating, not a tub-thumping motion from the Tories, and I hope it's rejected at decision time. Thank you, Deputy Presiding Officer.
Thank you. I now call Fulton McGregor, who will be the last open debate speaker.
Yeah, thank you, Presiding Officer. It's another day in another Tory debate in justice. We have had a few over the years, as others have said, but this one must be up there as one of the most ludicrous and obvious. As the Cabinet Secretary and others have already highlighted, it was just last year that this Parliament agreed to allow prisoners on short-term sentences to vote in order to be compatible with the European Convention on Human Rights. And prisoners on sentences of 12 months or less will likely be released during the next term of the Parliament. Why should they not get a vote when they will have already served their punishment? Rehabilitation is important for our communities, and if the Tories are serious about it, as Liam Kerr says, and serious about helping to break the pervasive cycle of reoffending, then we must all foster a culture of respect and tolerance, and that starts with government. Prisoners in short sentences will be expecting to be released during the next year. What message would it send to them if we're telling them they can't vote, they're not good enough to vote? Personally, Presiding Officer, and I don't mind saying this, I would go further. I think that any prisoner likely to be released during the next parliamentary term should have the right to vote for much the same reasons as I've already outlined. But I'd be open actually to this place having a conversation about going even further again, and all prisoners having the right to vote. It seems only right that people should be able to vote for the government that will ultimately make decisions about the institutions that they live in. Surely the COVID-19 situation has taught us all that. COVID-19 outbreaks in several prisons recently are perhaps an obvious illustration of the importance of this. Prisoners must have a right to have their say, like everyone else, in how this government and the other governments and local authority that they would get to vote in has handled the pandemic, for example. And I think what the Tories forget here is it's not just about prisoners themselves that are affected by the decisions. These people are someone's dad, mum, brother, sister, son, daughter and friend. As John Finney eloquently put, why shouldn't they have a right on their child's education, for example? And they are often victims themselves of horrendous circumstances, including poverty. Now, I know that extending the franchise to all prisoners is likely controversial, and there are numerous and competing ethical considerations to take into account, so I don't want to be misconstrued here. But I am saying that I would like this Parliament to have a discussion on it in the future and come to a balanced view. Whenever there is a change or extension to the franchise, there's always some opposition. Not long ago, during the independence referendum, I remember having discussions on the streets of Coatbridge and Christen with people when the 16 and 17-year-olds were given the vote. There were arguments saying, too young, no life experience, etc., etc. Well, these views were found to be unfounded, and I think we can all be proud of this move. And if we go further back, there would have been personalities and voices, often persuasive, in the early 1900s, arguing what a disaster it would be to give women the vote. The American William T. Sedgwick was one of these such voices saying, and I quote, "It would mean a degeneration and a degradation of human fibre which would turn back the hands of time 1,000 years. Hence it will probably never come, for mankind will not lightly abandon, at the call of a few fanatics, the hard-earned achievements of ages." Clearly an articulate and educated individual, and although I believe his legacy includes the founding of the joint MIT-Harvard School of Public Health, amongst other things, his views on suffrage have not aged well, and perhaps demonstrates to all of us the need for us, as parliamentarians and voices, to be bold and radical on the franchise from an earlier point in time. Presiding Officer, it's clear that the Tories don't want us to fulfil our human rights obligations, but how much further do they want us to go here? I presume they believe that prisoners should have fresh air to breathe. That would seem obvious. But what about water and food? Yeah, I think that they'd probably agree with that. But where does the line get drawn? What about family contact and access to medical treatment? Are they deserving of that? I would look for Liam Kerr or whoever summing up to maybe to let us know, because if they're saying they can't have a vote, they're essentially saying there is a line somewhere, and maybe we could get some answers on that. Presiding Officer, I see him at the end of my time, so let's be bold and let's be imaginative in our rehabilitation efforts. Prisoners serving short sentences of 12 months is the very least we can do, and urge the Chamber to reject the Tory motion and accept the government's. Thank you.
Thank you. We now move to closing speeches. And again, I remind members to stick to time and call Alex Riley. 4 minutes, please.
Thank you, Presiding Officer. I'm pleased to close for Labour in this debate brought to the Chamber today by the Scottish Tory Party, and to highlight their absolute blatant politicking ahead of the up-and-coming Scottish Parliament elections. Before even touching on the substantive issue to the debate we're having, it is worth pointing out that this Chamber has already, as others have said, had this debate. This Parliament has already decided by a supermajority, in fact this Parliament's first ever supermajority, to grant the extension of voting rights to some prisoners, those serving a custodial sentence of 12 months or less. When the Scottish Government consulted on this issue, the response mirrored the vote we had here in the Parliament, with 2/3 of respondents supporting the extension of the franchise. It is surprising that the Tories in this chamber have brought this debate today. They have long-standing a precedent of not supporting the extension of the voting franchise, and the only reason they have used parliamentary time to have this debate is to try and stir up controversy. It is, in fact, shameful of them to be politicking in such a barefaced way. Back in the Stage 1 debate on this issue, I said that I concurred with the views of the Standards, Procedures and Public Appointments Committee that policy on prisoner voting is driven by principle and evidence. This Parliament decided that the current blanket ban on prisoners voting was unsustainable, particularly given that it put our country at odds with the European Convention on Human Rights. The Scottish Centre for Crime and Justice Research pointed out at that time that Denmark, Sweden, Norway, Finland, Switzerland and Ireland have no electoral ban on prisoners being able to vote. The extension of the franchise simply brought us in line with other modern 21st century nations. The Tories have come here today to bring about a debate on whether or not we comply with human rights obligations. It is a reprehensible electoral ploy, and I have no doubt the Scottish public will see straight through it. Central to the debate, though, is what benefit do we as a society achieve by removing the right to vote of short-term prisoners. The purpose of prison is not simply punishment, but it is about rehabilitation. Active participation in civic society could well help with that rehabilitation aspect of what prison is about. I'm sorry, I have no time. You have brought forward a short 4-minute debate in order to score some political points. So that's why there is no time to have that debate further. All around the world, we see good practices of how to better deal with crime. Scotland has the highest prison population rate per head in Western Europe. We need to learn from good practice that we see in other countries, not try and score political points out of prisoners. The Tories are determined to frame this as a soft option approach, but it is not. It is an approach which respects human rights and helps reduce criminals from offending and indeed to reduce crime from happening in the first place. The lock them up and throw away the key approach does not work. Instead of grandstanding in this chamber, the Scottish Tories should take a long, hard look at whether or not they actually want to help tackle crime or simply punish offenders with no interest in rehabilitation and no interest in tackling the root causes of crime in this country. That would be a better use of our time.
Thank you very much. Michael Russell, 5 minutes, please. Cabinet Secretary.
Thank you, Presiding Officer. I always feel that parliamentary sessions suffer the same problems as aircraft do. The real difficulty is in take-off and landing. Actually, a parliamentary session itself can go fine, but the beginning and the end are always problematic. The beginning because the election is still being fought, and the end because, as Rhoda Grant indicated very clearly, we are already preparing for an election. And regrettably, this is an electoral ploy today. Now, I want to differentiate the views of those who honestly and strongly believe, as Liz Smith has given evidence of, that prisoner voting is wrong. I mean, I doubt whether I shall ever be number one in Mr. Harker-Johnson's fan club, and I noticed that Mr. Chapman described me in a piece in the Hollywood magazine as abrasive, arrogant, and he dislikes me. And therefore, I think I probably just have to live with that disappointment. But, exactly, I have to live with the disappointment. It may have something to do with the fact that I called him the Doric Donald Trump. But anyway, it doesn't really matter, because I want to make a genuine differentiation with Liz Smith's position. I do accept what she argues. I disagree with it profoundly. And I've got myself into a position in this issue where I would have said I didn't have a hard and fast view when I started with the bill, but I now have a view that actually accords much more closely with what Alec Rowley has said. I think if you look at the global issue, you discover that this is very much a product of history and penal history. And I think that when you look at other countries that have progressed beyond that and learnt from their history in the past, and it has been beneficial. I know I'm just going to have Liam Kerr is going to rise to his feet and say there's no evidence. I think there is increasing evidence that there are countries in which this has been beneficial. But let me differentiate that position that Liz Smith has taken with the question of why now? Why would you bring this debate to this chamber now? And why would you bring it when there is nothing that the Tory party can do about this? Well, there is. They could have brought a bill, presiding officers, I made clear in my opening remarks, they could have brought a bill and tried to get that bill through in the next 4 weeks. And then the victims that Liam Kerr talked about at the end, who he could look in the eye, he could look in their eye and said, we did everything we could do. We did everything we could do, and in the end, the Parliament turned us down. But that's not where we are. What we have here is, as Alec Rowley has made clear, and I have to say that John Finney made it even more clear. I know that I'm not in the Tory fan club, but my goodness, John, there must be models of John Finney with pins being stuck in them this afternoon after that. Because this is about naked politics this afternoon. And it was shown in Liam Kerr's opening speech. And I think if you want evidence, then that's where you should go for it. He described the fact that the SNP had pushed through this measure, although it was passed by the Parliament 92 votes to 27 across all the parties. So, I have, of course, not, as the Tories will no doubt quickly say, not a modest view of my own ability, but I have to say, even I could not push a bill through in that way. This was a bill that was decided upon by the Parliament. Mr Kerr also said, or rather, Mr Kerr didn't say, but coverage of this has included Tory assertions about SNP planning to give murderers and rapists vote. That is untrue. This is a very limited measure, and it is limited to sentences below 12 months. Deliberately so. And the Parliament debated, discussed that, and Mr Kelly referred to this at great length and decided that was the right place to pitch this. And thirdly, there was again an attack from the Conservatives on what they call the SNP soft touch justice policy. This wasn't about the principle of the matter. It wasn't about the fact that Parliament voted for it. It was politically targeted. And the reason, and Mr Rowley is correct, the reason we are debating this in very limited time here today is because the Conservatives think there's electoral advantage in so doing. They are not taking a single step to actually make this happen. And that is why, Presiding Officer, I repeat what I said in my opening. This is a cruel deception. It's not only shameful to do this in the Parliament, it's a deception for the victims, because it's telling them that something can be done and that the Tories intend to do something which they both cannot do and have not taken the necessary step to do. And that is the shame of this, because they could have done that. They would have been defeated, roundly defeated, but they could have come and done that. They didn't do it. So please, if you're going to come with such a naked political ploy, don't give the game away in the opening speech, as Mr Kerr did, because all the rest of it is just sound and fury and signifies nothing.
Thank you. I now call on Jamie Hartgrove-Johnson to wind up the debate. 6 minutes, Mr Hartgrove-Johnson.
Thank you, Presiding Officer. We meet today ahead of an election to this chamber that will be far from normal. It's already been radically altered by the ongoing pandemic and the restrictions on campaigning. But from a legal perspective, the most pressing difference is that the franchise will be, for the first time in a national election in Scotland, open to convicted prisoners under sentence. And I say national election because, as Liam Kerr pointed out, the Shetland by-election was the first step towards prisoner voting, brought in by ministerial order rather than by primary legislation. Unsurprisingly, beyond this chamber, these decisions have caused outrage and offence in equal measure. At the heart of the problem is that the Scottish Government's proposal hinges on a one-year sentence barrier as a measure of seriousness. The reality is that that is a poor barometer. To reach the threshold for a custodial sentence in Scotland, a serious offence must have been committed or a consistent pattern of criminal offending come to a head. Custodial sentences, even relatively short ones, are not handed down lightly by the courts. We can look to examples, as Liam Kerr raised at the beginning of the debate, of people convicted of serious sexual offences, homicides, assaults to severe injury and attempted murder who would find themselves this year enfranchised from their prison cells. If this is the Scottish Government's attempt to find a compromise between the position held by very few that all prisoners should vote and the view that prisoners should remain excluded, then it fails. And what message does this cobbled-together justification send to the victims of these offences? Victims who are told that the crimes committed against them are not of a serious nature. Ministers know, or they should know, as well as the rest of us, just how many severe crimes with a significant lasting effect fall into this bracket. Now, some will present this argument as a competition between a justice system that focuses on rehabilitation and one that focuses on punishment. Well, that's not my view. The UK government, addressing the ruling of the European Court of Human Rights, held that it was reasonable for people released on licence at the time of an election to vote. These are people who have been through the system, who have worked with it, and who are now being gradually reintegrated back into their communities. To grant them the rights that come with being part of that community is a more rational step, as Liz Smith highlighted. However, the Scottish Government has, by choice, gone further, giving the vote to those on short sentences from day one, when their involvement with wider society has, for good reason, been restricted. And as Liam Kerr emphasised, and which was touched upon by Liz Smith as well, there is not a single shred of evidence that prisoner voting reduces reoffending. We know from the situation in England that this was not essential, as ministers have sometimes tried to hint when they were pressed. There was no requirement in upholding the Convention rights to enfranchise people in prison. And while I recognise that some in the chamber have a long-standing moral commitment to prisoner voting, I find it hard for the Scottish Government to cast this as a moral argument. The First Minister herself spent the last election to this chamber opposing prisoner voting. Halfway through this session, she opposed prisoner voting. Now it appears, despite that opposition, her own Scottish Government rails against those who still believe that it is fundamentally wrong to have prisoner voting. Sadly, this is a government that has presided far too long over a justice system that does not meet the expectations of society. Sentences are frequently handed down that do not reflect the nature of offences. In too many cases, those before courts have lengthy histories of offending, but little evidence of punishment or rehabilitation. Too often there is a clear progressive increase in offending before an act takes place that can no longer be ignored. Even the words Police Scotland remind us of the many fiascos that have taken place in the short life of our single police force. As a consequence, metrics of crime, and particularly categories of violent crime, have been rising. Victims of crime can take little positive away from the actions of this government. Now, to turn briefly to some of the contributions today, my colleague Liam Kerr spoke about the range of offences dealt with by sentences of 1 year and under. Among the Scottish Government's talk of seriousness, we should find this chilling. And he's shown, as I expect we all know, that this situation was not necessary to comply with the European Court ruling, as Mike Russell's amendment suggests. Ministers and members should not hide behind the Hurst judgment to justify this approach. If they vote tonight in favour of that amendment, they should be honest with themselves and with the people who we are elected to serve. Liz Smith spoke about those who have committed a crime, who have broken a contract with society and through their own actions have chosen not to value the privilege of citizenship and have voluntarily put themselves outside the law. And Liz Smith also highlighted that those in this chamber who support prisoner voting do so in stark contrast to the majority of the public, some 63% who don't. Presiding officer, as the election approaches, prisoners have found a gold-plated view of their rights put forward, while the rights of victims often go unconsidered. On these benches, we've set out a different view, one that seeks to build safer communities, to make a solid investment in rehabilitation and to ensure that victims are given the support that they deserve. But above all, it's one that recognises that the justice system is essential, that it's something which must deal properly with offenders at all stages. And it should not be one that makes apologies for tackling crime, because as we look to the wider problems of some of our least advantaged communities, safety is a core need. It is the right of every person in Scotland to feel safe in their own homes, in the streets of their own communities, and too many do not, and we should not need reminding that this is a disgrace. So I urge members on the SNP, Labour and Liberal Democrat benches to reconsider their previous support for prisoner voting, to put the interests of victims, not perpetrators, of crime first, and to support Liam Kerr's motion today. Thank you.
Thank you very much. That concludes the debate on prisoner voting, and we will move on in a moment to the next item of business.